Canadian Jewish charity stripped of status fights CRA over potential multi-million-dollar tax bill. The Neiman Foundation of Canada, a non-profit organization known for donating to Israel, is currently engaged in a legal battle with the Canada Revenue Agency CRA. The CRA recently imposed an order that froze the foundation's assets, leaving it with the looming possibility of facing a multi-million-dollar tax bill. This tax bill stems from the foundation's charitable status being revoked in August 2024. The revocation of its charitable status came around the same time that the Jewish National Fund also had its status revoked by the CRA. The CRA claims that the Emunim Foundation failed to comply with several sections of the Income Tax Act, which apply to registered charities. The Foundation's legal team, led by lawyers Peter Swanstrom and Adam Aptowitzer, has filed a challenge against the CRA's jeopardy order, which was issued last December. This jeopardy order froze the Foundation's remaining assets and prohibited the group from disbursing its funds to other approved charities. Had the Foundation been allowed to transfer its remaining assets, it could have significantly reduced the $2.5 million revocation tax liability it now faces. Swanstrom argued that the jeopardy order is an exceptional remedy, stating that if it stands, it would end any possibility of reducing the revocation tax. He emphasized the grave consequences this decision would have for the Foundation's future, calling it game over for the charity. Christopher Van Berkom, a lawyer representing the Department of Justice, defended the CRA's imposition of the jeopardy order. He outlined the key reasons behind the order, citing concerns about the diminishment of the respondents' assets and the inability of the Neiman Foundation to prove that its funds would be directed to approved charities. Additionally, Van Berkom argued that the Foundation's activities post-revocation may not comply with the Income Tax Act, Chaim Katz, and the Emunim fund controversy. A significant part of the case centers around the actions of the Neiman Foundation's CEO, Chaim Katz. Katz, a Canadian immigrant to Israel, was listed as an ineligible individual when the Foundation's status was revoked. As an ineligible individual, Katz was barred from overseeing or managing any registered charity in Canada. However, Katz continued to be involved in charitable activities by assuming a leadership position with the Emunim Fund, another Canadian charity focused on philanthropy in Israel. After the Neiman Foundation lost its charity status, Katz redirected donors to the Emunim Fund for their contributions, raising questions about the legitimacy of this move. The CRA was alerted to these activities by a member of Independent Jewish Voices, who captured screenshots showing changes to the Neiman Foundation's donation page after the revocation. This evidence led the CRA to suspend the charitable status of the Emunim Fund the following month, as it appeared to be an attempt to circumvent the loss of status. Van Berkom argued that it was Katz's involvement with the Emunim Fund that triggered the CRA's action, stating it was only after the respondent's principal, Katz, engaged in these behaviors related to the Emunim Fund, did the court get this jeopardy application. In contrast, Swanstrom presented the argument that the evidence did not substantiate the CRA's claim that the collection of the revocation tax was in jeopardy. He suggested that the revocation tax could be nil under the circumstances and that the CRA's concerns were unfounded. A revocation tax is imposed when a charity's status is revoked, and it is calculated based on the value of the charity's remaining assets after debts have been settled. This tax can be reduced if the charity transfers its assets to another organization that maintains its charitable status. The CRA's decision to impose a jeopardy order was an attempt to ensure the Foundation's assets would not be lost before the tax debt could be collected. The jeopardy order serves as a safeguard to protect the government's interests when there is concern about the charity's ability to pay the revocation tax. CRA's concerns and the 5-year delay. Swanstrom also brought attention to a significant delay between the CRA's initial notice to revoke the Emunim Foundation as charitable status and the agency's more recent concerns about the jeopardy of collecting the tax. He argued that the 5-year delay indicated that the CRA's worries were not as urgent as they now appeared to be. The Minister of National Revenue's attempt to manufacture jeopardy now, Swanstrom said, where she was previously not concerned by it, ought to be rejected by this court. This statement suggests that the Foundation believes the CRA has only recently raised concerns, possibly as a way to justify its actions. The Emunim Foundation's legal team is challenging the timing of the CRA's concerns, asserting that there was no genuine risk of the foundation evading its tax obligations. Justice Simon Fothergill, who presided over the case in federal court in Toronto, has not issued a decision as of the last proceedings. This leaves the future of the Emunim Foundation and its fight against the revocation tax in a state of uncertainty. The Foundation's financial struggles have been compounded by the CRA's decision to freeze its assets and prevent the transfer of remaining funds to other approved charities. As the case progresses, the Emunim Foundation hopes to present its evidence in a way that convinces the court to reverse the jeopardy order and allow the Foundation to operate freely again. The Emunim Foundation's purpose and financial status. According to the CRA's official profile of the Emunim Foundation, its stated mission was to provide relief to the needy through food, clothing, and shelter. The foundation also sought to advance the Jewish faith by teaching religious doctrines and observances and by offering spiritual and educational resources to Jews in Israel. The Emunim Foundation's financial records for the 2023 fiscal year show nearly $9.3 million in revenue and approximately $9.7 million in expenses. This suggests that the foundation had substantial financial resources and commitments, and the revocation of its charitable status has had significant consequences on its operations. In the wake of these developments, Bloomberg, a prominent expert on Canadian charity law, commented on the rarity of the CRA's actions in this case. He stated, "This type of action by CRA is rare in the charity area and would only be used if CRA has a very significant concern that charitable funds will not be available to pay a revocation tax." Bloomberg further explained that the Charities Directorate has shifted to a more risk-based approach when it comes to compliance with charity regulations. This approach has led the CRA to act more swiftly in cases where non-compliance with charity rules is suspected, which could explain the speed of the actions taken against the Emunim Foundation. The CRA's initial revocation decision was based on the Foundation's failure to meet several requirements outlined in the Income Tax Act. These failures included the inability to devote sufficient resources to its charitable activities, poor record keeping, and the failure to issue proper donation receipts. The Emunim Foundation's response and accusations of persecution. The Emunim Foundation of Canada has strongly criticized the CRA's decision to revoke its status and impose the jeopardy order. In a statement to Jewish Philanthropy, a digital publication covering Jewish philanthropic news, the foundation referred to the CRA's actions as a travesty of justice. The foundation argued that the CRA was targeting Jewish charities that support Israel, accusing the agency of a bias against these organizations. The Emunim Foundation's leaders feel that the CRA is less interested in ensuring compliance with charity laws and more focused on persecuting groups with ties to Israel. This sentiment has resonated strongly within the Jewish community, which has expressed concerns about the treatment of Jewish charities by Canadian regulatory bodies. Despite these challenges, the Emunim Foundation has continued its charitable activities, redirecting donations to the Emunim Fund, which has taken on the foundation's mission in Israel. This redirection of funds after the revocation of the foundation's status has been a key issue in the case, as the CRA views it as a circumvention of the law. The outcome of this legal battle will likely set a significant precedent for how the CRA handles similar cases in the future. The Foundation remains committed to defending its actions and seeking justice for what it perceives as an unjust treatment by the Canadian government.